على أشرف الأنبياء والمرسلين نبينا محمد وعلى آله وصحبه أجمعين. أهلا ومرحبا بكم في اليوم الثاني لهذا المؤتمر، مؤتمر التحكيم المؤسسي. ننطلق هذا اليوم مع موضوع مهم يهم جميع المحكمين ومن يتحاكمون وأطراف النزاع، ألا وهو التحكيم المؤسسي في تسوية المنازعات بين الدول والمستثمرين. نحن نعلم جميعاً أن رأس المال والمستثمر دائماً يبحث عن حل المنازعات السريعة التي يطمئن لها الأطراف حينما ينشأ الخلاف. لذلك كان التحكيم أحد أهم حل هذه المنازعات والتسوية بالطرق السلمية. معنا المتحدثين، سوف نبدأ بالأستاذ مايكل جويس، وسوف يتكلم عن وسائل تسوية المنازعات المستثمرين والدول. Please, Mike, you have the floor.
Assalamu alaikum, Your Highness, Your Excellencies, distinguished guests. I'd like to begin by thanking the Saudi Center for Commercial Arbitration, their board of directors and their officers for the kind and generous invitation to participate and to speak at this very important conference. In my 12 or 15 minutes, I want to do 4 things. First of all, I'd like to sketch a brief history of investor-state dispute settlement. I'd then like to look at the existing balance between the interests of investors on the one hand and states on the other. I'd then like to look at some of the problems of the existing system. And finally, I'd like to ask what can or should be done looking to the future. Turning to the first element, a brief history of investor-state dispute settlement. Until the 1990s, there was very little protection for foreign investors when they made an investment in another state. That was placing a fetter on the development, on economic development. So in the 1990s, BITs, or bilateral investment treaties, emerged, and they emerged as a very strong trend during that decade. They emerged because capital exporting countries wanted protection for their investors, and capital importing countries were looking for foreign investment for economic development. So about 500 bilateral investment treaties were concluded during the 1990s. Since then, over 3,300 bilateral investment treaties had been concluded by the end of 2016, which is the most recent date that I have a figure for. So, in essence, as has been described by another commentator, what was created was a de facto global regime. The key element of that global regime was that BITs, bilateral investment treaties, enabled investors to bring claims in arbitration for damages if the host state applied sovereign regulatory measures which were incompatible with the BIT, the treaty. Of course, there is an inevitable time lapse between a treaty being entered into, investment being made, and disputes, and those disputes in turn proceeding to arbitrations. So that in the early 1990s, there were really very few ISDIS cases, investor-state dispute settlement cases. But as of the end of 2017, there were 855 known treaty-based investor-state arbitrations. And the reason for that enormous development was twofold. Essentially, sovereign regulatory measures became more pervasive, but also there was what I've termed an expansionist approach of ISDS arbitral tribunals. Before we look in that in a little bit more detail, it might be helpful just to look at the geographic spread of the cases that I've mentioned. In the Central and East European, Central Asian area of the world, that accounts for 26%, just over a quarter of the cases. South America, just under a quarter. Sub-Saharan Africa, 15%, and the MENA region, 11%, with no other geographic region exceeding 10%. So what one can see from this list is that the emerging world, very often nations which were poorer than the richer nations, found themselves confronted by claims for very substantial damages and very substantial costs in the process of resolving these disputes. The result, almost inevitably, was what happened, namely that there was a backlash. States considered that investor-state dispute settlement regime was too investor-friendly, and there was a view that state-investor balance needed recalibration. Turning to the second element of what I'm talking about today, namely, what was the balance, what were the mechanisms, the checks, the balances between investors and states? Let me take the doctrine of the fork in the road as an example. The fork in the road essentially said that if an investor chooses to litigate a dispute in the domestic courts of the host state, then it loses the right to arbitrate the dispute under a bilateral investment treaty or an international investment agreement. Now, of course, that sounds very sensible. You have literally the fork in the road. You choose one route, you're precluded from taking the other route, at least in theory. But the question really is, how have these limiting practices, limiting principles, been applied in practice? Looking in context, there are perhaps 4 types of limits that states have tried to impose. They've tried to impose scope limitations on BITs by saying that the BIT will only cover treaty claims and not anything else. States have tried to apply carve-outs from the BIT and therefore limit the scope of the BIT. They've also said, well, we need to have a cooling off period, a waiting period, so a time limitation, putting in time in the hope that matters can be negotiated. Choice limitations, this is the fork in the road. You choose one route, you're precluded from going down another route. There have also been sequencing limitations, a requirement to exhaust local or domestic remedies. On the other side of the equation, however, investors and, in large part, arbitral tribunals have tried and sought to expand the scope of investor-state dispute settlement. So in terms of expanding the scope, what is an investment? It's not defined in the ICSID Convention, and arbitral tribunals have given a very wide meaning to the word. There are vague or imprecise concepts: fair and equitable treatment, full protection and security. Even expropriation, which may seem to be relatively precise, does taxation amount to expropriation or not? There's then been the use of most favored nation clauses. In other words, one country has to be treated in no lesser way than the relationship between the host state and any other country. So you can search for a more preferable regime in other treaties. The use of umbrella clauses. As far as time, it's been held that waiting periods are not mandatory or jurisdictional. They are instead merely procedural and directory. In terms of the fork in the road, arbitral tribunals and investors have said there has to be identicality of party, identicality of claims, and identicality of issues. And that can severely limit the scope of the fork in the road choice. Treaty claims, they can be seen as jurisdictionally and juridically different. So in other words, even though you have got claims in another forum, you can still bring your treaty claim. And sequencing claims, there's been a very indulgent view taken of what amounts to exhaustion of local remedies. Let me move to the third point, which is Let me move to the third point, which is some of the problems. First and foremost, one must ask what is investor-state dispute resolution? Some have termed it privatized governance. So is there a question mark even over the legitimacy of the decision-making powers of ISDS tribunals? Is there a need for a proportionality framework? And can tribunals create a global administrative governance standard through the publication of awards? Can that publication create a global consistency? All of these issues fall within privatized governance. There's then the vagueness of the language that I've already referred to. What is and is not fair and equitable treatment? So you have uncertainty of scope, and up to a quarter of claims are rejected through declining of jurisdiction, a trend which has been mildly increasing. There is also the problem of inconsistent decisions, the absence of any jurisprudence constante with no appeal process. Complaints about weak reasoning in awards, failure to grapple with the complexities, and little more than, well, I'll know it when I see it, in terms of the rationale. Is there a chilling effect on sovereign policy space? What that should be properly the domain of a sovereign nation. A country in financial crisis may see necessity in one way. Subsequently, years later, a tribunal may see those same circumstances in different lights. There have even been examples of tribunals second-guessing Supreme Courts, and India felt very strongly about that and has indeed adapted its own bilateral investment treaties in the light of its own experience. It's also important to ask, is there a structural bias? Is this a North construct imposed on South states? And there's a growing feeling that investment arbitration, or investments, extend beyond pure business and finance to include environmental considerations, public health considerations, labor and social standards. How are all these to be accommodated within the ISDS regime? There have also been questions over independence and impartiality of arbitrators. Do parties appoint a sympathetic arbitrator? Is there a conflict of interest between someone who is an arbitrator in one case and counsel in another? And what about repeat appointments by states, by the same law firms, repeat appointments to determine similar issues? It might be of interest that literally last week at the International Bar Association conference, a draft report on consistency, efficiency and transparency in investment treaty arbitration was published. As you can see, I have a copy and I plan to make a copy available to the Saudi Centre. Let me skip the final slide on this section and ask whether we're at a turning point with regard to investor-state arbitration. Is there a systemic tension in the system? Is there a systemic imbalance in favour of investors? Are there new system dynamics? And is there a need for independent, reasoned review? Is there a need for an appeal mechanism? Is there a need for a permanent international investment court? In summary, we are perhaps at our own fork in the road. Is investor-state dispute settlement arbitration fit for the purpose? Do we need a court? Should we be considering investor-state mediation? But at the end of the day, are all of these possibilities in search of the same goal? As I say at the end of this slide, it may be that a broader global shift is underway that could lead to new standards of foreign investment regulation. Thank you indeed for listening, and I'll be happy to take questions in due course.
Thank you. Thank you, Mike. الآن يتحدث إلينا لويس كريستوف ديلانو عن مبدأ رضا الدولة في المنازعات المستثمرين والدول في ضوء المبادئ المطبقة حديثاً. Luis, please.
Your Highness, Excellencies, ladies and gentlemen, dear friends of Saudi Arabia, it is my pleasure to now discuss before you the concept of state consent in investor-state dispute. I will not be using slides because there is too much content in them for the time I have, but if any of you is interested with the slides, I'll be happy to forward them after the presentation. As any arbitration, investment arbitration, which is an arbitration between an investor and the state on the territory of which this person has made an investment, is based on the disputing parties' consent and agreement. So we need the consent of the investor, but we need the consent of the state. States, and only states, can give such a consent in three different ways. First, under a contract that they sign with a private investor, and the parties agree that if they have disputes, they will be submitted to arbitration. It is the traditional classical way of giving consent to arbitration. Second, states can consent to investment arbitration under a domestic law for the promotion of foreign investments. Under such a law, they give guarantees to foreign investors, and they give a sort of anticipated consent to investment arbitration. The first time an arbitral tribunal has found that a consent could be given in this way was in 1988 in the famous exit case SPP versus Egypt, in which my firm happened to be counsel for Egypt. Thirdly, states can also consent to investment arbitration under treaties, bilateral treaties or multilateral treaties. In these treaties, again, states grant guarantees to foreign investors, nationals of the other states signatories of the treaty, and they give an anticipated consent or make a standing offer to arbitrate disputes they might have with these investors. Today, out of 10 investment disputes, about 8 or more are based on treaties. And this is why I'm going to focus on treaties, on the consent given by the states under an investment treaty. And I have 2 points to make. First, I'd like to highlight the unique features of such a consent. This is compared to a consent given under a contract, because these features are to be found also when consent is given under a domestic law. But again, today, the bulk of investment disputes are based on treaties. And second, I would like to address the threats that currently exist and may jeopardize this consent under treaties. The unique features of state consent under a treaty are connected to the fact that when states enter into investment treaties and give anticipated consent to investment arbitration, they don't know anything about the disputes they might have in the future. They don't know who will bring the dispute, what will be the subject matter, in what circumstances the dispute will have emerged and developed. When you sign a contract with an investor, you know the party's obligations. Each party knows that if it fulfills its obligations under the contract, there should be no dispute. But under a treaty, you know nothing. So what states do, as Michael already observed a few minutes ago, is that they don't give a blank and sweeping consent to arbitrate any dispute with anyone under any circumstance under a treaty. They delimit, frame, shape their consent by identifying the beneficiaries of consent, the disputes which will be eligible for arbitration. And also they like to set some prerequisites, not to jump to arbitration as soon as there is a disagreement between a state and an investor. And states under treaties are always respondents. This is because investors are not parties to the treaties. They do not take any commitments. States do. And if an investor finds that the state has breached a guarantee or a right conferred to it under a treaty, then they initiate arbitral proceedings and states are respondents. As any respondent, states like to try to destroy the claimant's case. They raise defenses, and the first defense they raise is denying the jurisdiction of the tribunal, because they say, I did not consent to an arbitration with this claimant or for this dispute, etc. And this gives rise to many discussions and many debates before arbitral tribunals. To illustrate how states shape their consent, you could take as an example the bilateral investment treaty signed by Saudi Arabia with Japan in 2013. It is easily accessible on the internet. Article 14.8 contains the consent of the states as a matter of principle to resolve disputes through arbitration. But immediately the states define the beneficiaries of consent. They are, for a state, the investors of the other state. So Article 1.3 defines the notion of investor of a contracting party. They may be natural persons, they may be companies. I will not read the provisions for the sake of time, but you may read them. They contain precise elements. And these elements also give rise to objections from the respondent states. They say, this claimant is not a proper company of my contracting party under the treaty because it doesn't fulfill this or this condition provided for under the treaty. Of course, the treaties define the notion of investment. They have to. So this is for the beneficiaries. They define the treaties, the disputes which may be brought to arbitration. In the Saudi Arabia-Japan BIT, Article 14.1 states that the disputes that could be brought to arbitration are those emerging from a loss or damage an investor states it has suffered by reason of a breach of the treaty by the host state. Thirdly, states like to set prerequisites. In the Saudi-Japan Treaty, Article 14.4, learns us that the investor has to send a notice of dispute to the host state to explain that it intends to bring a dispute. This triggers a period of 6 months during which the parties must try to find an amicable settlement. If they fail, and if the investor has not seized the local courts or administrative agencies, then the investor must send a second notice to the state at least 90 days prior to starting arbitration. This notice must contain information on the nature of the claim, the amounts claimed, etc. And then Article 14.9 provides for a sort of statute of limitations. The investor must not wait more than 5 years as of the date when he or she was aware of the damage alleged. If this 5-year period is lapsed, no claim will be brought to arbitration under this treaty. So this is how states shape their consent. The second feature is that they don't know necessarily how to avoid a dispute. If you have a contract, again, if you fulfill your obligations, you know you should have no dispute. But because under these treaties, states promise to treat the investments under certain standards, such as the fair and equitable treatment or the full protection and security. As Michael stressed, these notions are not precisely defined. So it is for each tribunal to give a definition and to decide whether this act or omission of the state is a breach of the standard. And this creates uncertainty. So much for the features. Now my second point, the threats on state consent under treaties. I can see 2 threats. The first one is not new. I would call it the arbitral threat. Arbitral tribunals may sometimes ignore the exact consent a state has given. They may unwittingly expand the scope of the state's consent. This can be, for example, because some treaties are badly written. I take the example of the 1992 Turkey-Turkmenistan Treaty. Article 7 says that if the disputes have not been settled through negotiation after 6 months, they can be brought to arbitration, provided that, I quote, if the investor concerned has brought the dispute before the courts of justice of the party that is a party to the dispute, that is the host state, and a final award has not been rendered within 1 year. Literally, this provision does not mean anything. You have to delete a word in it to give it a meaning. If you delete the word if the investor has seized the local courts, it means the investor must, it's mandatory to bring the dispute first to the courts of the host state. And it's only if no award has been rendered within 1 year that this investor will be able to go to arbitration. This is what the tribunal in 2012 decided. 3 years later, another tribunal, in a case where I was counsel for the investor, looked at the word if. If the investor seizes the local cause, he must have no final judgment within 1 year to go to arbitration. But there is the word if, meaning that seizing the local courts is an option, not an obligation. And a third tribunal 1 year later found that it was mandatory to seize the local courts, but that it was not a jurisdictional issue, but a matter of admissibility of the claims. So one provision, 3 tribunals, 3 different solutions. In some other cases, tribunals may be tempted to create a consent that could never exist. This is, in my opinion, the case of the Crimean cases. You know that in 2014, Russia has annexed Crimea, which was part of Ukraine. There is a treaty between Russia and Ukraine for the protection of foreign investments. As all of these treaties, the intention of the parties was to attract Russian investments in Ukraine or Ukrainian investments in Russia. But after Russia annexed Crimea, a number of Crimean investors who had made a purely domestic investment, they were based in Kiev, they invested in Crimea, which was part of Ukraine, said we are entitled to the protection of this treaty because now Crimea is under the Russian control. Well, I submit that it is nonsensical to think that Ukraine and Russia entered into this treaty thinking if Russia invades part of Ukraine, domestic Ukrainian investments will be protected because they will be transformed into Ukrainian investments in Russia. So now, at this very moment, the Swiss Federal Tribunal is holding a public hearing where 5 judges will give their positions as to whether this treaty applies because the tribunal was seized by Russia of request for annulment. So this arbitral threat may have triggered the political threat which Michael has addressed, meaning that some states today are taking steps backwards, narrowing or even withdrawing their consent to investment arbitration. To conclude, if investments must be treated fairly and equitably, so must states. They must be treated fairly and equitably by arbitral tribunals, and they must feel that they are. If they don't feel this, they will step backwards, and this will be detrimental to investor state in arbitration.
Thank you, Luis. That's a good speech. والآن يتحدث إلينا بول فيدراند عن استخدام المتنامي لتمويل الطرف الثالث في منازعات المستثمرين والدول، إشكاليات قائمة حول الإفصاح وتأمين التكاليف.
Assalamu alaikum. I'm very grateful to the organizers, Your Excellencies and Your Highness, for this invitation. My subject is third-party funding. It's a subject that attracts a lot of attention within the international arbitration community. Third-party funding somehow seems categorically different than what came before. So different that many in the international arbitration world take the position that third-party funding is to be specially regulated and made the subject of mandatory disclosure. I'm going to consider during this brief talk the subject of disclosure of third-party funding, whether and how. Before I do so, it's worthwhile to consider if it's true that third-party funding is so new and different. Every claimant gets funding from some source. The funding could be friends.
The funding could be a bank. The funding could be investors who want a piece of any recovery. This is the way it has been for centuries. No one has ever said before that a claimant has to disclose how it gets the funds to mount its case. And if I'm a claimant in an arbitration, and I ask one of you to help me out to finance the case, why should our arrangement be disclosed to anyone? Wouldn't we have a legitimate expectation of privacy as to our funding arrangement, both its terms and its very existence? No one, for example, says that insurance coverage needs to be disclosed. And yet insurers, like funders, sometimes pay counsel fees. We all, though, instinctively know that there's a difference between third-party funding and insurance. Third-party funders get a piece of the recovery. Insurers don't. Their remuneration is through premiums, fixed long before the dispute. And there's another important distinction. Insurers may occasionally provide loans for lawsuits, but it's not the prime business of any established insurer, to my knowledge. And because it's a marginal aspect of the insurance business, there's no need and no call to regulate it. How about lenders? No one has ever said that loan agreements that provide funding for a case need to be disclosed as a matter of policy. But here again, we can quickly identify the difference with third-party funding. A lender typically has a right of repayment regardless of outcome. And loan agreements don't provide that repayment on the loan varies depending upon the amount of the recovery. And, as with insurers, lenders' primary business isn't lending money for lawsuits. So again, there's no cause to regulate a marginal banking business. Now, definitions of third-party funding to date have focused on whether they qualify as a party in interest in a case. This makes sense to an extent because it's accepted that every party in interest should be disclosed to arbitrators on the other side. The parent of a subsidiary, for example, is routinely disclosed when the subsidiary is the party. Under that definition, a third-party funder is quite clearly a party in interest, given its stake in the outcome of the case. But that approach, I suggest, doesn't capture the essence of the distinction between funders and other arguable parties in interest, such as lenders and insurers. And it doesn't explain the reason why disclosure of third-party funding is advocated by so many. The reason, rather, is the combination of a funder's interest in the outcome of a case and the funding business model. Funders, of course, are not in business to fund just a single case. Instead, a funder in one case, let's call it case one, may be funding other cases which involve the same arbitrators or counsel or even parties as in case one. And that may give rise to questions of impartiality and independence that need to be considered, and the only way for these questions to be considered is through disclosure. A recent ICA report on third-party funding gives a salient example of this. In the example, the presiding arbitrator in a case is a partner in a law firm, and one of his partners serves as counsel to a claimant in another case. In both cases, the same funder is funding the claimants. We can assume that the partner of the presiding arbitrator is bringing in substantial fees from the funder, and these fees benefit the presiding arbitrator to the extent of his or her interest as a partner of the firm. In situations such as these, the party not being funded, the respondent, has a legitimate reason to be informed of circumstances that may put in question whether the presiding arbitrator has a conflict of interest. The respondent, once informed, might not want to challenge the presiding arbitrator, but the respondent should still be enabled to make an informed decision, and the respondent's interest is especially acute in the new world of portfolio funding, where a funder enters into an ongoing relationship with a law firm to fund multiple clients of that firm. So the question becomes how to assure that the respondent will be put on notice. It wouldn't work to require an investigation on the part of the presiding arbitrators as to what his or her partners are up to. The burden can't be on the arbitrator. Instead, the party being funded should be the one to make a disclosure. And the only practical way to do this is by a request to all parties at the outset of a case, with a duty to supplement that response if something changes during the course of the case. But that doesn't quite resolve the issue. A question remains whether this should be an automatic request or one made only on a case-by-case basis where one party raises the subject. There are good reasons to make it automatic and mandatory. If it's not, the burden falls on a party, the respondent, to make a request. But how is the respondent to know to make the request? And if it's left to the respondent to raise the subject, does that imply that there is a certain threshold that the respondent's application must meet in order to justify disclosure? Wouldn't it be simpler just to require disclosure? The answer seems to be yes, just require disclosure. But I give that answer unhappily. I'm unhappy about it because I viscerally resist another step on the path to legislative disclosure. There are so many cases where the subject of third-party funding disclosure is irrelevant. Where, for example, each arbitrator is a solo practitioner, there's no real risk that any arbitrator will have an undisclosed financial connection to a third-party funder. But when I pursue this line of argument too far, making the point that in most cases third-party funding won't give rise to a potential conflict, I don't resolve the objection at the back of my mind that it may sometimes raise a conflict. And how is a respondent to know when it does? So I come back to mandatory disclosure, but only as to the fact of funding and the name of the funder. The other party has no need to know the terms of the funding agreement. Now, there's also a legitimate question whether disclosure needs to be made to the respondent or only to arbitrators or the institution. To the extent disclosure is made only to the arbitrators and the institution, we arguably satisfy claimant's interest in privacy, and we resolve the problem of conflicts by arbitrators. So I'm going to close on this. One way to look at the whole third-party funding disclosure issue is, what's the big deal about disclosing the mere fact of funding and the identity of the funder? Why not just require this on a routine basis in order to avoid undisclosed conflicts and leave the subject behind? I'm sympathetic to that perspective, but I continue to be as sympathetic to the argument that it's a priori a claimant's business and no one else's how that claimant chooses to fund its case. I recognize, though, that this interest in privacy has to give way before the greater need to assure that a case proceeds before an unbiased and unconflicted tribunal. Now, in my comments up to this moment, I've discussed third-party funding without considering whether anything changes if we narrow our focus to investor-state disputes, and investor-states disputes, as we know, is the subject of this session. When we do narrow our focus to investor-state disputes, I think that the balance must shift and does shift toward mandatory disclosure. The attacks that we've all seen and that have been referenced this morning on the legitimacy of the supposedly pro-investor nature of investment arbitration require some adaptation on the part of the international arbitration community. And requiring disclosure of third-party funding in the investor-state context is a modest and relatively painless adjustment. For commercial cases, the debate can still be had. But even there, the vector of international arbitration is toward disclosure. We can see this in the ICA report that I mentioned. We can see this in this region, in the DIFC's recent rule change requiring disclosure of third-party funding for cases before the DIFC. And in the investor-state world, we can certainly see this in the new proposed ICSID rules providing for disclosure of third-party funding. So the argument that I've explored in favor of the privacy side of this debate may be lamenting the departure of a train that's already left the station. Thank you.
Thank you, Paul. والآن ننتقل إلى المتحدث الرابع والأخير الدكتور كيم جونجي. سوف يتحدث عن تطبيق مبدأ المنع القانوني من قبل هيئات التحكيم في منازعات الاستثمار الدولي. Please, Kim.
Assalamu alaikum. It's a great pleasure to be here. I'd like to thank Dr. Mira, Dr. Ghaffar, and of course, Mr. Mogira. What I propose to do is talk about a very specific topic, a doctrinal topic called estoppel, and how it is developed in investment arbitration. What I'll do in the short time that I have is I'll begin with the definition of estoppel, and then I'll briefly look at how the jurisprudence has developed, and then look at the ramifications of this concept. Of course, all of us, many of us here are lawyers, and of course are familiar with the general concept of estoppel, but it has a very interesting thing we need to learn, particularly from international law perspective. The first thing I begin with is a quote from James Crawford, a very prominent arbitration international law specialist who sits on the International Court of Justice. And this is what James Crawford says. He says, an estoppel is precisely not a unilateral act. Not a unilateral act. It is a representation, the truth of which the entity on whose belief it is made is precluded from denying in certain circumstances. So the key thing here we need to focus on is preclusion. Estoppel is about preclusion. Basically, the simple way to think about it, I think, is it's a shield. It's a shield against a sword. That's all it is. It's estoppel. There are some other concepts that are related to estoppel. And one is a very often cited Latin phrase, and I'm no expert in Latin, but it's allegans contraria non addiendus. What does this mean? It's very simple. A person adducing to the contrary is not to be heard. If you say something contrary, we're not going to hear you. You cannot say something is hot and it's cold at the same time. If you say it's hot, it's hot. You can't say it's cold. This is related, of course, to the general concept of good faith. And good faith is often considered the basis of estoppel. Moving on, Estoppel is also oftentimes talked about with various other concepts. And of course, among them are things like waiver, acquiescence, and recognition. And there's a lot of overlap in these concepts at many times, and sometimes they can exist at the same time. If we try to distinguish, one way to think about it is, waiver is something where you're giving away your rights. And recognition and acquiescence can actually create obligations. But again, as we said about estoppel is just the shield. It's just preclusion. You're not necessarily giving up a right or creating an obligation. It's just the shield against the sword. Now, this is the classical, traditional definition of estoppel that's been developed by the International Court of Justice from a public international law standpoint. It requires three things. It requires that there be a clear and unequivocal representation of fact. That's the first prong. The second prong is it has to be voluntary. This representation made by someone has to be voluntary, unconditional, and authorized. That's the second prong. The third prong is where a lot of the debate occurs. The third prong is this representation has to be relied upon in good faith to the other party's detriment or the advantage of the party that made the statement. The big debate that goes on right now about estoppel is whether the third prong should be included or not. The traditional classical view is you have to have all three prongs. Some, however, debate, and many tribunals we find have actually not considered the third prong. And they think the first prong and the second prong is enough. I will call that the broad view, the traditional view versus the broad view. Moving along, looking at the first prong, it's supposed to be a clear, unequivocal representation of fact. What's the representation? Representation can occur in many forms. It can occur by word. Someone can say something. It could be by conduct, by how a party has conducted themselves. Or it can be by silence. It can also be considered a representation. If we look at the second prong deals with the representation. But how is it represented? And who made the representation? A simple example would be if a firefighter or an aircraft controller made a representation. Can we consider that a representation on behalf of a party, of government? Probably not. Taking a look at the third prong is about reliance. And the reliance has to be reasonable. Some would say it has to be foreseeable. If you say, it's gonna snow in the summer, nobody's gonna believe that's not reasonable. It has to be a reasonable reliance and it has to be a foreseeable reliance. Now, estoppel can occur throughout the process of arbitration. It can be at the jurisdiction phase, it can be at the merit phase, it can provide procedural issues, it can involve quantum, it can involve the annulment process. Throughout the arbitration proceedings, estoppel arguments are made. So it's constantly made all the time. And it's made, of course, by claimants and respondents. Both sides make estoppel arguments to each other, using that shield. Another debate occurs that some tribunals, investment tribunals, have actually considered estoppel for representations of law. And we have seen this, most recently, for instance, in the Yukos case, where representations of law were considered a shield for estoppel. And of course, some are critical of that. As we saw, the traditional view is no, it's only for representations of fact. So I close with an interesting case, the most recent ICSID case involving estoppel. In a 2011 a case brought by company investor Cambodia Power against Cambodia. We have a very eminent tribunal, Neil Kaplan, John Beachy, and Toby Landau. And what the claimant tried to do is they wanted to include a state entity as one of the respondents. Now, under ICSID practice, what's supposed to happen is the state, Cambodia, is supposed to designate all the agents of its government. And only those agents could be potentially brought in as a respondent. So the claimant's argument was, no, they wanted to use the shield. You cannot deny that that entity, the state-owned enterprise, should not be included. We've basically designated that entity, so they should be included. That was their argument. So you should be stopped from denying it. You can't use your shield to deny my argument. Interestingly, the tribunal dismissed the case on all three bases, all three prongs. I'll only focus on the last prong, though. The last prong was there was no detriment. Why was there no detriment? It's very interesting. Their argument was if you exclude the state-owned entity, you will still have recourse. You can still bring a private, separate claim outside of ICSID, an ICC claim, against that party. So you don't have any detriment if we exclude the entity from the ICSID claim. Therefore, no detriment, among other things, so they denied the estoppel argument. The conclusion is that for the investment tribunals that adopt the traditional approach of all three prongs, consistently so far what we found is if they adopt all three prongs, they'll deny the estoppel argument. If they adopt the broader approach, it only applies to two prongs, the first and second prong, however, we find a mix. Some tribunals have accepted the estoppel claim, our shield, and some have not. So this is what we have to look for in the future as to whether this will be a trend, whether tribunals will continue to adopt the traditional approach, or whether they'll go more toward this broader approach that only considers the first two prongs. Thank you very much.
Thank you, Kim. ننتقل الآن إلى المناقشات والأسئلة، والفكرة الآن أن نأخذ جميع الأسئلة من لكم ثم نعطيها المتحدثين. فمن لديه سؤال أو تعليق فليتفضل. تفضل. هل فيه
Assalamu alaikum. Good morning, Your Highness, and good morning, fellow speakers, and thank you for your very informative presentations. My question is for Michael, and I also invite the panel to comment or answer any part of it if they deem it appropriate. The question relates to at least two claims brought by private investors against two sovereign states, and each investor has invoked the dispute resolution clause under the Organization of Islamic States. First case, the respondent country did not acknowledge the dispute, the notice, and argued that the dispute resolution clause under the OIS did not give the right to private investors to bring claims against a sovereign state. And as a result, that country did not appoint an arbitrator. And the petitioner went to the Secretary General of the OIS asking that he appoints an arbitrator, and the Secretary General refused to do so. Now, a second case emerged, and I'm purposely not mentioning names of the countries or parties, and the same facts, without repeating them, took place, except the petitioner, after the Secretary General of OIS did not appoint an arbitrator, went to the PCA, Permanent Court of Arbitration, and asked that an arbitrator representing that respondent country be named. And the PCA did, in fact, appoint an arbitrator, from what I understand. Now, my question to you is made up of two parts, really. The second part is the easier one, and it relates to the authority of the PCA to appoint an arbitrator in a multi-state treaty between the Islamic states. And the more important question is, do you, based on your experience, believe that the dispute resolution clause in the Organization of Islamic States did, in fact, give private parties to bring state investor disputes, claims against sovereign states? Thank you very much.
تفضل.
Thank you, Your Highness, and thank you, everyone in the panel. Actually, my question is for Mr. Denali. We spoke about the interpretation of texts regarding consent of states in state investor disputes. This is a major issue and a very important issue because it causes conflicts and security for investors if they want to sue states or have a dispute with a state. If they don't have some kind of security of how legal texts of treaties or other governing documents, then how could they have security to how these texts should be interpreted by arbitration bodies? There are, as you know, several ways to interpret legal texts. Are there from international arbitral bodies some standards to how such texts should be interpreted? That's, I think, a major issue should be discussed, and what are ideas, practical ideas to solve such problem? Because conflicts, as you gave some examples in interpreting, could cause problems. Thank you.
السلام عليكم. في عندي طال عمرك ملاحظة لسموكم الكريم، وفي عندي مداخلة طبيعتها بالإنجليزي وجهها للأستاذ لويس. الأولى، عندنا في منطقة الخليج arbitration center، هذا موجود في البحرين وصار شغال أكثر من 15 سنة، وأنا عضو في اللجنة الفنية. هذا واحد. فمن رأيي وسموكم أفضل رأي أن نستعين بالخلفية والإمكانات المتوفرة هناك لتدعيم المركز هنا. الملاحظة الثانية، طال عمرك I will talk in English to Mr. Lewis. Our problem here for the arbitration, we lack the legal mechanisms. For example, we don't have the standards, especially in technical issues, mainly environmental liabilities. So in this case, we rely on other international liabilities or regulations, such as the Civil Liability Convention or Basel Convention but those are not approved by the legal system here. So how can we adapt such mechanism? Thank you.
شكرا سمو الأمير. أحمد نجم، الأمين العام لمركز التحكيم التجاري دول مجلس التعاون. طبعا شدني موضوع the third party funding and the investment treaty. موضوع جدا شيق ومن الأهمية تحويط هذا الموضوع. فسؤالي: is the third party funding designed to take advantage of the symmetric structure of the investment regime today, just to take the benefit of the speculative finance, or it is because of the crisis finance that we face today? Thank you.
شكرا. تفضل.
My question to the panel is that the concept of third-party litigation funding, should this concept entail some control over the third-party funders themselves? To what extent the third-party funders should be controlled for exercising influence on the actual parties?
شكرا.
My name is Majid Al-Otaibi, a professor of international law at King Saud University. And first of all, I would thank the panel for this discussion and welcome them to the country of love and peace, Saudi Arabia. And I have a question about, we know the debate and international investment law is now subject to the debate and development, ongoing debate and development. And the problem with international investment law, I think, is related to its principles. Like, for example, fair and equitable treatment, which many investors use to sue host state. It's not clear, and you can see the difference in the arbitral award given by different tribunal. Like, for example, even in the treaties itself, like NAFTA, if we take NAFTA as example, they linked fair and equitable treatment to the minimum standards. While other states, including Saudi Arabia, they make it like broad, they didn't make it specific to the minimum standards.
Sure.
This is the first question. Last question about the cost of the investment claim. Like, if we take the cost as Argentina in 2004, we see a claim against Argentina equal to $16 billion, which is equal to 1% of a gross domestic product of Argentina. Do you think the cost of a claim, of the cost of investment claims, cause a problem to investment arbitration, which makes some countries, especially developing countries, to rethink about the bilateral investment treaties? That's it. Thank you so much.
Thank you. تفضل هناك القسم الثاني.
I am Bashir bin Yamin from Dar al-Hikmah University, the representing team of Saudi Arabia in the West arbitration moot. My question is to Mr. Paul. To what extent does third-party funders intervene in the arbitral proceedings? Thank you.
في أي سؤال آخر ولا نبدأ بالإجابة؟ ناخذ آخر سؤال هنا. تفضل.
المحامي خالد المعادي، محامي ومحكم. أنا عندي سؤالي للأستاذ بول. الإفصاح عن التمويل يكون قبل التحكيم أو في لائحة التحكيم؟ 2، هل هو إلزامي على حسب مركز التحكيم أم لابد يكون نص موجود في عقد التحكيم؟
شكرا. إذا نكتفي بالأسئلة الآن وننتقل إلى الإجابات. Michael, we'll start with you now, and please have the floor.
Your Highness, thank you very much. I make that 8 questions, and I think questions 1 and 6 are principally directed in my direction. So I'll go first with those and invite my colleagues to comment appropriately, and then I'll do likewise when they're dealing with questions directed towards them. Let me go back to the first question. And I have to premise and preface my answer by saying that free legal advice is, of course, worth every real pound or dollar that you pay for it. And as this constitutes free legal advice, I've now established its value. And the reason why I do that is because, of course, it was a very detailed question arising from the dispute resolution clause in relation to the Organization of Slavic States, and 2 very similar fact situations with an extra element in the second situation, namely an appointment by the Permanent Court of Arbitration in circumstances where the General Secretary of the initial organization had not made an appointment. I'm asked to consider 2 points. Do I believe that the dispute resolution clause in the underlying agreement gives the petitioner authority to bring the claim? And secondly, what are my views about the authority of the Permanent Court of Arbitration to appoint an arbitrator in these circumstances? I think the first answer is an answer of general application, and that is that there is no substitute for going back and reading the provision and really working through the provision in question, the provisions in question, to understand A, what they say, and B, what the scope of the provision is. So far as the second question is concerned, I must say when you outlined the factual circumstances, I raised an eyebrow, either physically or metaphorically, in relation to what had happened, but I would assume that the Permanent Court of Arbitration had considered the point and considered it extremely carefully, and had decided that they did have authority in those circumstances. If I were called upon to review that decision to see whether there was any basis for challenge, then I would need to consider the circumstances and also the action on the part of the Permanent Court of Arbitration extremely carefully. If I can go on to the 6th question, which was the ongoing debate and development in relation to investor-state arbitration and the elasticity of provisions such as fair and equitable treatment, and you referred to the NAFTA Convention. Of course, this brings us back to one of the main themes that I was at least floating, if not addressing, in the 15 minutes that I had available. Questions of consistency, questions of inevitable and inherent vagueness and therefore uncertainty in the terms which are inevitably used. And also you were talking about the tension, and this is a tension which is rightly there and which I didn't have time to bring out, but the tension between minimum standards of treatment under international customary law and a higher standard which is created under a bilateral investment treaty. I think you're absolutely right that all of these matters need to be addressed, and it prompts the very rethink that you referred to at the end of your question. I think that we are, as I said at the end of what I was saying, at a fork in the road in the way forward, at least in terms of needing to have a debate to see whether we need to recalibrate the balance between investors and state.
Thank you, Mike. Rئيس, please.
Thank you, Your Highness. I have noted at least 1 and possibly 2 questions put to me. The first one is on the interpretation of treaties by arbitral tribunals, because we have noted some uncertainty and some different outcomes, and we were asked about any principles of interpretation which might give some guidance. Well, as a matter of, I would say, both fact and law, since treaty-based arbitrations apply international law because treaties are part of international law, as you might check if you read Article 38 of the Statute of the International Court of Justice. The arbitral tribunals do consistently apply the rules of the Vienna Convention on the Law of Treaties of 1969, which are deemed to be representative of the customary international law, even if the respondent state is not a member state to the Vienna Convention. And the basic principle of the rules of interpretation of the Convention is to look for the common intentions of the parties. This is notably Article 31 of the VCLT. The problem is that when the intentions of the parties is difficult to ascertain because the treaty is poorly written, when the preparatory works or other elements to which you may refer according to the Vienna Convention are missing or insufficient, you may apply very good principles of interpretation, and it still leaves some uncertainty, and it may still lead to conflicting results. I couldn't say more. To identify why a treaty is poorly written, sometimes you have to do some treaty archaeology, and you can go back to the source of the flaw in the text, but I cannot give details on this now. I think another question from the gentleman from Bahrain turned on the principles to be applied in matter of liability, and what principles would you apply? Here again, the arbitral tribunals refer consistently to international jurisprudence. For instance, for the magnitude of the compensation, they almost all refer to the Shores of Factory case after the First World War. And there is, I think, a path towards more consistency here, all the more so that the awards in investment arbitration are almost all made public, so you may have references. A last point, maybe not on a question I would have seen as addressed to me, but on Michael, on the fair and equitable treatment and the, for instance, the NAFTA way of applying this. Under NAFTA, there was a specific commission which could give definitions and precise notions, and this was done for the FET, and it became binding on the tribunal. To eliminate uncertainties on these issues, there is a tendency now either to have more precise wording in the treaties or to institute commissions, as the European Union has done in its trade agreement with Canada, which will be allowed to give binding interpretations on arbitrators. Thank you.
Thank you, Luis. I'll give the floor now to Paul, please.
Yes, I think there were 4 questions that addressed third-party funding, and I'll take the first 2 together. The first invoked the concept of crisis financing, and the second talked broadly about the issue of control of third-party funding. I take them together because I detect, I could be wrong, that the premise of both questions is that there is something dangerous about third-party funding that needs to be controlled. And I don't accept that premise, and I don't because third-party funding is a business, and it's a business that works only to the extent that they fund meritorious claims that are likely to prevail. The danger evoked about third-party funding is that funders will fund frivolous claims. Now that might happen, but if that happens, then the third-party funder is not doing its work properly. Now the third question was from the lady, and was about the question of to what extent do third-party funders in fact intervene in the control of a case? And in my experience, there's a wide variety. And it depends in part on their deference to counsel and the counsel's own expertise, and it depends in large part on the energy of the third-party funder and their own sense of their own expertise in international arbitration. Now, there's an underlying question is, does it matter to what extent the funder controls a case? If there's a parent of a subsidiary, it might turn, and the subsidiary is the party, it might turn out the general counsel of the parent is actually controlling the case and making decisions about arbitrator selection, etc., and even counsel selection. Does that matter? Is it an inherent danger in itself that the third-party funding, in some cases, is controlling the case on the part of the claimant? I'm not sure it does. I'm not sure it is a problem. Now, the fourth question, I want to apologize in advance. There was a translation issue, and I'm frankly not sure I got it. There was a question about funding in the arbitration contract itself. That's something I haven't seen, but if I misunderstood the question, I suggest that we get together after the session, and I'll be happy to try to answer it. To the extent the question concerned the regulation of funding in arbitral rules, well, that's what's happening now. That's the direction of international arbitration. Thank you.
Thank you, Paul. Please go.
I'll touch upon the question of the amount of claims that are made by investors. I would recommend that there's some excellent work done by Professor Susan Frank on this topic. And according to her research, the average claim by investors is $340 million. That's the average claim amount. But the interesting part is the average award. The average award by tribunals is only 3% of that, $10 million. And then, of course, the next stage after that is, that's the arbitral award, but actually how much does the investor actually receive at the end? Just in terms of that statistical analysis that has been done. The other issue that I think the questionnaire touched upon is what is called, I think, a regulatory chill. That if an investor brings such a large claim that it will restrict the state in their regulatory powers and their discretion to carry out their regulatory activity. But there's a lot of academic studies that show that the regulatory chill argument actually doesn't hold up and that it doesn't really affect the way the states behave. Thank you.
Thank you. في الحقيقة تردني كثير من الأسئلة والكثير يريد الإجابة عليها، وهي حول الشريعة الإسلامية. ما مدى تطابق الشريعة الإسلامية مع الأنظمة الحديثة والدولية العالمية؟ هل تتفق معها؟ هل تختلف؟ هل تستوعبها؟ أريد أن أؤكد مسائل متأصلة في الشريعة الإسلامية، وأريد أن أبسطها كثيراً، وأقول أي نظام أو قانون في العالم أياً كان مصدره، أقول أي قانون أو نظام في العالم أياً كان مصدره، في الغرب، في الشرق، في أوروبا، في الجنوب، في الشمال، أي نظام لا يخالف الشريعة الإسلامية فهو من الشريعة الإسلامية، بمعنى أن الأصل الإباحة في المعاملات. ولذلك استوعبت الشريعة الإسلامية الأنظمة العالمية، ومن خلال الدراسات والمقارنات وجدنا أن تطابق إلى أكثر من 90% على حسب ما هو موجود الآن. تختلف من دولة لأخرى، ترتفع إلى 95، تنزل إلى 90 على حسب. هذه هي الشريعة الإسلامية التي نفتخر بها والتي صالحة لكل زمان ومكان منذ أكثر من 1400 سنة. والسبب هي المرونة في الأنظمة. لم تأتي في المعاملات إلا بعض الأمور التي حرمتها الشريعة. أما البقية فهي الأصل. ولذلك والقاعدة الشرعية المعروفة العقد شرعة المتعاقدين، فأصبحت العقد بين طرفين هو عبارة عن شريعة إذا لم تخالف الشريعة. فأنا أشكركم للاستماع، أشكر المتحدثين جميعا الذين أسمعونا اليوم آخر التطورات في التحكيم على المستوى العالمي والمؤسسي. أشكر الحضور ومن تفاعل معنا اليوم في الأسئلة والأجوبة، وأتمنى لنا ولكم الاستفادة من هذا المؤتمر. نشكر القائمين عليه وعلى الجهود المبذولة فيه، والسلام عليكم ورحمة الله وبركاته.
شكرا صاحب السمو. Thank you our distinguished guest. الآن عندنا استراحة لمدة 15 دقيقة، ومن ثم نعاود إن شاء الله تعالى الجلسة الخامسة، وهي تحت عنوان حل نزاعات تجارة النفط والغاز الدولية. Thank you so much. We'll have break for 15 minutes and we will resume إن شاء الله تعالى for the session 4, which has the title Institutional Arbitration and the Settlement of Investor-State Dispute. Thank you so much.